Hello and welcome to 42BR's Employment Law webinar series. This is the fourth and final session in our current employment law series and the last for 2025. I'm Iris Ferber, KC.
I'm Max Gordon.
And today, Max and I are going to be talking about harassment, or more precisely, harassment versus harassment. Max, your topic, very nice. A practical comparison between the Equality Act and the Protection from Harassment Act 1997. Now, all previous recordings in this employment law webinar series can be found on our website. If you have any questions for us, please put them into the Q&A box, not into the chat box, so that we can see them. If we have enough time, we will address them at the end of the session. If we do run out of time, or if you're watching this as a recording and you'd like to ask some questions, please send your questions to events@42br.com. and we will come back to you as soon as possible. And finally, before we get going, an email containing this recording and the feedback form will be circulated to everybody who signed up over the next few days. So, Max, there are two very different types of harassment claims. As employment lawyers, the one that's very familiar to us is the Equality Act in Section 26 of the Equality Act. But there is also a very different statute called the Protection from Harassment Act of 1997, a much older act. When might each of these get used? How might a practitioner use each of these acts? What are the limitations to each type of claim? What remedies are available? And can claims in the civil courts using the Protection from Harassment Act provide a solution to a problem that an Equality Act claim can't?
Yes, and we don't often see them sort of used interchangeably. And like you say, in employment, we see the Equality Act used a lot more. As a background, we also consider some of the authorities. There's the matter of Madrowski and Guys and St Thomas NHS Trust. It's a House of Lords matter.
And it's an old case, isn't it now, 2006?
Yes, I suppose sometimes you say 2006, it doesn't feel that old, but it is.
Quite a long time.
It's getting some
more than 10 years
time
ago.
back. And this was relevant for vicarious liability, something we are quite often see in Equality Act. But what that matter confirmed is that an employer can be vicariously liable under the 1997 Act as well for acts of harassment that are committed by employees in the course of their employment.
Okay, so that's important, isn't it, for us employment lawyers? Because in reality, most of the time that we're dealing with events that might constitute harassment, those are events between two individuals, and one of them is accusing the other one of harassment, and that person, the accuser says, is acting in the course of employment for their employer.
Yes.
So it matters that you can use a claim under the Protection from Harassment Act, even if the individual doing the harassing is just an employee of that company.
Yes, exactly.
And that's what the House of Lords said in Madrowski. Now, when really, you might ask me, does a harassment claim under the Protection from Harassment Act come up? When is it something that you might even want to look at as in what might otherwise be an ordinary employment-related situation? Well, look at the case, if you haven't already heard of it, of Titan Wealth Holdings and Okunola from 2024. You might not have come across it because it's not an employment tribunal case. It's a high court case. But in Titan Wealth Holdings, the 1997 Act was used to protect employees from a campaign of harassment which had been conducted against them by a former employee of Titan.
Yes. Some slightly unusual facts from that matter. So Ms. Okunola was dismissed, as you say, after only 11 days of employment. The ET claims that were brought failed.
So she failed in her case?
Yes, she was claimant in an employment tribunal, and that failed and came to an end.
Okay.
And after that point, she then rather embarked on what's described as a campaign to damage Titan's reputation. And this involved sending messages to two particular senior managers. There was a suggestion that one of them was linked to Adolf Hitler somehow.
Okay, that's quite serious.
Referred to the other's personal hygiene, and then also suggested that they had both secured these senior positions they held and the promotion through sexual favours.
Okay, so extremely serious and nasty allegations.
Yes, absolutely. There was also some doctored images involving these two managers. That was rather sort of indecent images, and they weren't obviously originals. They were altered.
So AI generated, and this was all Miss Okunola had done all of this as part of her campaign.
Exactly. And then these messages were sent to the managers in question, but then also sent to quite a large number of people sort of within their professional circle. The exact number of those people not ascertained, but it went out to a broader population as well.
Right, so that really does seem extreme. I think we're all familiar, sadly, with cases in which a dismissed employee behaves in an unreasonable way towards a former employer.
Yes.
It happens, but this was an extreme situation where two individuals were particularly targeted.
Exactly. It's not just the company, it was targeting them as well.
Absolutely. And it was the two individuals, wasn't it, Max, who applied to the High Court for the injunction. They were claimants with Titan Wealth Management, and that was an injunction application to prevent Miss Okunola from further harassment and also for damages for the effect of that behaviour on each of those two individuals.
Yes, so the two elements you can have under the 1997 Act.
Absolutely. And so, unsurprisingly, in that particular case last year to 2024, the High Court held the messages comfortably met the threshold for harassment, and we're going to talk about that threshold in a minute. They granted an injunction and they awarded damages. Now, can you guess how much damages they might award for that sort of behaviour?
Without having already seen it in the notes, no, I wouldn't have guessed. It's
a lot, isn't it? I think it seems to me, compared to what an employment tribunal would award, I don't know. It was £15,000 per individual for the acts of harassment. So, what do you think? Is that comparable to injury to feelings in an employment?
I think it could be. It's not a single incident, is it? I'm in my mind, I'm placing it in vento bans.
So that's right, exactly. Whereas, of course, it's worth saying it's not a vento banned case.
Absolutely.
But it's a sort of comparable thing. The difference, of course, being that we're talking about an individual or two individuals pursuing another individual for that money. So this is an ex-employee paying out £30,000 in damages to each of two individuals. Interesting. So that's the scenario from Titan Wealth Management.
So at that point, I think let's just have a brief moment to go back to basics. Look at the building blocks of each part. So if I'll start on the Equality Act side of things. So we're talking about Section 26. And what that breaks down is a person, A, harasses another, B, if A engages in unwanted conduct. So unwanted conduct is the first element.
Yeah.
And that related to a relevant protected characteristic. Now, it's a very important point for the Equality Act, which we'll circle back round on. And the conduct has then the purpose or effect, and there is a difference between the two, of violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. Now, that's quite a long list. Those words are sometimes considered to be interchangeable, and they can be broken down a bit. And what is meant by environment also could be quite significant. I jumped down then slightly, as there's some extra wording, but I don't think we need to slow down too much to subsection 4.
Of Section 26?
Of Section 26.
So we're still in Section 26?
Yes.
Okay.
Because that is focusing on in deciding if the conduct has the effect. So if it has the purpose, that's the end of it.
So if you're doing an act of harassment on purpose to harass somebody related to their protected characteristic, that's all that's needed.
Exactly.
But if that wasn't your purpose, then the question is the effect on the individual that feels harassed.
Yes, and that is often more the common point. And explored by employment tribunals, obviously, for conduct to actually be found to have the purpose is a lot more rare.
Absolutely.
So if it has had the effect, and often the main person who obviously is going to give evidence on that is going to be the complainant themselves. They're the person who says they have felt this effect.
Yeah.
Then the tribunal would go on to consider the perception of B, the perception of the complainant, the other circumstances of the case, so sort of the surrounding facts of how the conduct has really happened, and then also whether it is reasonable for the conduct to have had that effect. So there's a reasonableness element put into the test.
Okay, so Section 26, there's the definition of harassment, and then there's part of that definition is it has to have the effect, the harassing effect, and the harassing effect part means, first of all, it has to the victim, the alleged victim, has to have that perception.
Yes.
And then the tribunal has to consider all the circumstances of the case in considering that. And it not only has the alleged victim not only has to have that perception, but it has to be reasonable for that person to have that perception. There is an element of objectivity to some extent to that person's perception.
Yes, so I have seen an employment tribunal matter in which the effect was accepted, but it was found that it was not reasonable for the conduct.
Might be worth each of us giving an example of that, because we've each had cases where that's happened. So I had a case in which an individual was given feedback on an employment application, an application for a job, and it was described to her as mixed feedback. And she found that to be harassing conduct, or to her perception, it was harassing conduct because she believed that the word mixed was a reference to her mixed race.
Right.
Tribunal found that even if you honestly believed that, it wasn't reasonable for you to have that perception of the word mixed, the phrase mixed feedback, as an example of where the reasonableness comes into it.
Yes, the one I've seen, and I know this is sometimes had mixed outcomes in the tribunal, is where a word has been used and it's perhaps the context of the word.
Yeah.
So in my matter, it was for a large retailer and it was a customer feedback form. And it was trying to compliment actually someone who had assisted this customer, and they were trying to describe the employee, and they described the employee as coloured.
And that was a customer who described the employee.
The customer. So it's not the employer.
Yeah.
And also, and a point we'll come on to, this was not about the complainant who actually then brought this complaint to the tribunal. And that doesn't necessarily mean that you can't then bring a claim under Section 26. But the complainant in that matter, the claimant, became aware of this email, which had been circulated in sort of a batch. Here's the customer reviews from the last week sort of thing. This had not been picked up or seen by anybody. And he found it offensive. And so it had the effect. But in that case, the tribunal, with all those surrounding circumstances, found that it was not reasonable to have that effect.
So it really is quite fact sensitive, that question of whether or not it's reasonable.
Yes, on each different case.
And then finally, the protected characteristics that the harassment has to be related to. They're not all of the protected characteristics that are in the Equality Act, which is sometimes a pitfall.
Yes, absolutely. And it's saying or setting out how that conduct relates to that protected characteristic is often a point that the harassment claims fall down on. But subsection 5 of Section 26, still the same section, sets out the relevant protected characteristics. So it's age, disability, gender reassignment, race, religion or belief, sex, or sexual orientation.
And the one that's missing is pregnancy.
Yes.
So you cannot be harassed in relation to your pregnancy. You have to fit that harassing conduct, if that's what you're alleging, into sex as a characteristic, which is how it tends to happen. But those are the specifics of Section 26. Okay, I think that was very useful to go through as a building block to the comparison of the two types of claim, Max. And then let's talk a bit about the Protection from Harassment Act 1997 then. The prohibition on harassment is set out in Section 1. Of the act. It's a short act, by the way. It really just deals with harassment, civil and criminal. Yes. And it defines what those are, and it says what the remedies are, civil and criminal. And Section 1 starts with what prohibition of harassment means, and what that is in subsection 1 of Section 1 of the 1997 Act is that a person must not pursue a course of conduct, and we'll come back to what that means.
Key point.
Key phrase. Person must not pursue a course of conduct which amounts to harassment of another. For an employment lawyer, that's bad drafting. What? You can't pursue a course of conduct that amounts to harassment. Well, okay, but what does harassment mean? Exactly. So again, we'll come back to that. Must not pursue a course of conduct which amounts to harassment of another and which he knows or ought to know amounts to harassment of the other. So this is set up much more like you'd expect from an ordinary civil or criminal, a criminal offence or a civil tort, which is what are the facts that have to be proved and what is the intention of the individual. So the facts are course of conduct which amounts to harassment. The intention is knowledge, or the state of mind is either knowledge or ought to know that conduct amounts to harassment of the other. And then in Section 7, so that's the first part of Section 1. Section 7 of the Protection from Harassment Act contains the interpretation provisions of the Act. And it says two particularly important things in subsection 2 of Section 7, that a reference to harassing a person includes alarming that person or causing that person distress. Now, includes leaves it open for there to be another way of defining harassment, but in practical terms, these cases turn on whether the behaviour alarmed the claimant, because it would be a claimant who would be suing for harassment.
Yes.
So the claimant would be the person who alleges they've been harassed. So has the claimant been alarmed, or has the claimant been caused distress? That's the facts that the claimant has to prove the harassment. And we mentioned course of conduct, and what does that mean? And we remember that the person who is the defendant to that claim is not allowed to pursue a course of conduct amounting to harassment, not just an act of harassment. And a course of conduct means, in subsection 3 of the interpretation section, conduct on at least 2 occasions relating to that one alleged victim.
Yes.
So the claimant has to have suffered alarming or distressing conduct on at least 2 occasions in order to be able to make a claim under the Protection from Harassment Act 1997.
Yes, and authorities confirm just alarming or distress. It's just given its natural interpretation, its natural meaning.
There's no technical sense to that. Absolutely. So pretty broad. And the subsection 2, going back to section 1, and the what harassment is, the person whose course of conduct is in question, so that's the alleged harasser,
Yes.
That person ought to know, I'm putting rabbit ears around that. So what does ought to know mean? If that's defined in section 1, subsection 2, ought to know means that a reasonable person in possession of the same information as the defendant would think the course of conduct involved harassment of the other person. So that's what ought to know means. A reasonable person would think that it did.
Yes, reasonable bystander, sort of.
Reasonable as in an objective. I mean, what we really mean as lawyers by a reasonable person is the judge decides. Generally speaking, reasonable person means it's an objective test and the judge decides what's reasonable. That's the reality. Sorry, folks, that's the reality of the reasonable person test. And then there are a number of defences, but the most important one, I think, is that the harassment provisions don't apply. So in other words, a course of conduct isn't harassment if the person who did it, the defendant, shows that in particular circumstances, the course of conduct was reasonable. So to take a silly example, if a policeman is following you because they suspect you of doing something criminal, that's going to be reasonable.
Yeah.
If I follow you because I am stalking you, that's not reasonable. It's all in the context, and it's all in what the particular circumstances of the course of conduct are. And then I'm going to say something about remedy. So we haven't particularly covered what the remedy is for Section 26 harassment, but I think we know as employment lawyers what it is, don't we? Which is, in an employment tribunal, you're going to get compensation.
Yes.
Aren't you? If you succeed in a Section 26 harassment claim, there'll be an injury to feelings vento award for that. Well, and this is really an important difference. Section 1, protection from harassment claim, allows the victim to take advantage of Section 3 of the protection from harassment claim, which lists the civil remedies. So forget going to the police and getting them to criminally prosecute that person. That's ultimately out of our hands. If we're the victims of harassment, we ask the police to deal with it, and they do or they don't. But in terms of bringing your own civil claim as a victim of harassment, you're entitled under Section 3 of the Protection from Harassment Act to bring that claim. And if you do bring that claim, you are entitled both to damages, not only for financial losses, which would be the normal loss in a civil claim, but also for the feelings of anxiety and distress and any other negative feelings that are caused to you by that harassing behaviour. And it's what we would call injury to feelings, but in the civil courts, it doesn't have that name. In practical terms, it's going to be the same sorts of considerations. So damages for the feelings that you have as a result of being harassed, as well as any financial losses that arise from the harassment. And importantly, in High Court or County Court proceedings for protection for claims under the Protection from Harassment Act 1997, the victim can obtain an injunction.
Yes, and I think that's what people often think of first under the Protection from Harassment Act, in my mind.
I think that's right. And it's what I think probably a non-lawyer might call a restraining order.
Yes,
That
exactly.
is essentially what we're talking about. And it was enacted actually in 1997, partly at least because of stalking and because of the perception that there wasn't really a civil remedy for stalking. You had to go to the police, ask them to take action. If they didn't, there's nothing you could do about it. Well, since 1997, there has been effectively a civil wrong of stalking, which is the Protection from Harassment statutory tort. And under that tort, as we've described, you have to have your two separate events against you, which cause you alarm or distress. You can then take that to the civil county court and you get your injunction. And the value of an injunction is two things, isn't it, Max? From our non-employment practice. Firstly, it's that you get an order from the court that says the person mustn't approach you, mustn't communicate with you, whatever it is that you ask the court to do. It's very flexible what you put into an injunction, and it would depend on the behaviour of that person that you're trying to stop.
Yes,
but
again,
just as important, fact sensitive, just as important is what happens if they breach the injunction.
Yes,
which is something that we simply don't deal with in the employment tribunal, which is if a defendant has an injunction made by a court against them and they breach it,
you're in contempt.
You're in contempt, and then you could be
enforcement proceedings. You could be in prison.
You could be in prison. So there is a real difference in the seriousness of an injunction compared to a tribunal order, which yes orders payment of money but can't actually do anything else. And if what you need, like Titan Wealth Management needed, was to stop the person from behaving in the way that they were behaving, not the money's fine, but actually it's to stop the person from behaving in that way, then what you need is a county court or high court injunction.
And I think that's one of the key differences. If you've got ongoing conduct, then yes, perhaps you would be more inclined to go towards the Protection from Harassment Act.
And it's worth just finally adding that Section 3 of the Protection from Harassment Act also makes it clear that breaches of an injunction or alleged breach of an injunction under the Protection from Harassment Act entitles the person who alleges the breach to go straight to the police for an arrest. Yeah. So it's a very quick process from this person has breached their injunction to a policeman turning up at their door and arresting them, which is the point to a great extent of running that claim, is to have the option of getting that injunction and then enforcing it quickly.
It's to give you that tool, isn't it?
Absolutely. So that's the overview of Section 26. That's the overview of Section 1 of the Protection from Harassment Act. So let's go back and actually focus, Max, on the differences then. What are the differences, practically speaking, between running an Equality Act case for harassment and running a Protection from Harassment Act claim for harassment?
Well, starting with the Equality Act, I think the key definition, going through the building blocks that we just went through, is the Equality Act claim has to relate to the protected characteristic.
Right, and that can be difficult. A person may think something relates to their race or their sex, but there might be no evidence of that, actually.
Yes, and it's a very common thing to see. You see someone complains of bullying or some form of unwanted conduct, but if it then does not relate, it could be for any other reason. If it's not because of your protected characteristics, so your age or your race or whatever you perhaps think it is, if you can't then
you can't make the connection.
You can't make that connection. You could have the conduct and it can quite clearly be unwanted, but it's not then going to be a Section 26 harassment claim.
So one of the key distinctions is if you've got a client who says, I've been harassed or bullied, but there is actually no connection with the protected characteristic, it may be that it's worth at least discussing with them the possibility of a 1997 Act claim as an alternative.
Exactly, because you don't have that requirement, obviously, under the 1997 Act.
But I mean, it is perhaps, just while we're chatting about this, worth highlighting right at this point that if you do have a client who has that situation where there isn't the connection with the Protected Act and you are talking to them about the possibility of a 1997 Act civil claim, you have to give them very different advice about costs. Because in an employment tribunal, the employment tribunal is, to all intents and purposes, a cost-free jurisdiction. You give every claimant that you advise a warning about the possibility of unreasonable costs arising, but you also tell them that that's, as long as everything is run properly in the litigation and everybody behaves themselves, that's extremely unlikely.
Yes.
Whereas in a Protection from Harassment civil claim in the county court, the normal cost rules of the county court apply. You're a defendant and you lose that case and you get an injunction made against you or damages awarded for harassment, you're paying that claimant's legal costs. And conversely, of course, you are a claimant issuing a claim in the county court or high court for harassment and you don't make out your claim, you're paying the defendant's costs for defending it.
Yes.
So that's an important warning about the practical differences between these two types of case.
Yeah.
Okay, so big difference, no need in the county court to connect the behaviour to a protected characteristic, requirement in the employment tribunal to connect the behaviour to a protected characteristic.
The second point, I think, would be the context. So under the Equality Act, we're talking about employment circumstances, whereas that doesn't necessarily have to be the case for protection from Harassment Act.
Right, okay, that makes sense. So the way the Equality Act is structured, you have first part, which is all of the fundamental principles and definitions. You've got then different parts, 2, 3, 4, 5, 6, which specify the scope of each part of the Act. So employment,
yes, we're on
education, premises, public functions. And if you can't fit your relationship with the other person within either, as you say, part 2, part 3, part 4, etc., then there isn't a discrimination claim there. Right. Yes. Now, we're used to, in employment litigation, it's always employment. Exactly. But it's worth highlighting that the Protection from Harassment Act and Section 1, which we've talked about just now, is really where everything you need is contained for bringing a claim, other than the definitions section and the remedies section. So Section 1 contains the entire definition. No reference there to what relationship you might have with the other person. It could be anyone at all, couldn't it?
Yes, absolutely.
And in fact, it's quite common for it to be a neighbour that you have nothing to do with, except that you see them every day and they are harassing you, for example.
Yeah.
Okay, so Section 26, protected characteristic connection is required, and there has to be an employment relationship there.
On a point of vicarious liability, which we've already mentioned while we're going over the basic principles. So under Section 109, your employer can be liable for the unwanted conduct of an employee.
And in fact, that's completely normal, isn't it? We have that in almost basically, without having to quote it, we have that in every case.
Pretty much. And you'll sometimes see claims against the employer, just against the employer. Sometimes the claim is also brought against the employee who is said to have conducted the unwanted conduct.
But you always say, don't you, as a claimant, Mr. Bloggs did this to me, but I'm also suing my employer because they are vicariously liable for Mr. Bloggs's behaviour.
Exactly. And that vicarious liability can attach even if your employer is not aware or didn't approve that conduct, or they acted without approval.
Well, there is a defence, though,
yes,
for an employer.
There is. So the main defence raised, and you often see it certainly at least pleaded, is an employer can rely on a defence that it took all reasonable steps.
Yeah, so the reasonable steps defence is Section 109, subsection 4, isn't it? And we've each seen it pleaded.
Yes.
Have you ever seen it run?
No, I've never actually seen it relied upon.
Okay, I've tried it once in a case about 20 years ago, and it went unbelievably badly for my client who was the respondent, basically. And I've heard anecdotally that other people have had the same experience over the years, that basically if you're running a case where there's been some proven act of harassment by an employee, and you as an employer are saying, look, I took all reasonable steps to stop my employees from behaving this way, a judge won't have it.
I struggle to think exactly what you would present. You often see, or there's an element in the evidence that says, well, we run annual training,
or we monthly training,
yes,
or whatever.
We have this employee handbook and we have this guidance.
Yeah. It's rarely enough.
Yes.
Everybody has those systems in place, and in general, judges just don't accept that those are sufficient to amount to reasonable steps.
As for clarity, we're not saying that those systems in place, that they're not useless. Of course, it could help prevent the harassment in the first place.
And you certainly will be in great difficulty if you don't have those systems in place. That it's effectively, in terms of due diligence, it's an obligation to have those policies. But the reality is that as the statutory defence to harassment and discrimination more generally, of taking reasonable steps to prevent employees from carrying out that sort of behaviour, it very, very rarely succeeds. I'd be amazed if anybody watching this webinar has ever had a reasonable steps defence succeed, but I'd be interested to know if anybody has. Right, okay, so that's interesting because there isn't, that's a statutory defence in the Equality Act. That does not exist in the Protection from Harassment Act. It's simply not a part of the structure of Section 1 of the Protection from Harassment Act. So if you've got the House of Lords case that you mentioned from 2006, Madrowski and Guys and St Thomas's, an employer is vicariously liable. As long as the employee who is harassing the other person was acting in the course of their employment,
yes,
then the employer is going to be liable, and there is no get out that says the employer can avoid liability if they took all reasonable steps to prevent that person.
No, that last point is it may come a particular point of dispute is going to be, was it in the course of employment potentially?
Absolutely. But the case law on vicarious liability over the last 20 years has given very little wiggle room to employers for avoiding that kind of for avoiding liability on that basis. So course of employment is basically these people are connected by their employment. Person X did something to person Y, therefore it's in the course of employment. That is generally speaking how these things work.
Pretty much.
But it is worth saying, isn't it, that because it is so difficult to prove the statutory defence, perhaps the difference between the two claims where Section 26 statutory defence available, Section 1 Protection from Harassment Act statutory defence not available because there isn't one, is perhaps more something in the textbooks than in the real world, because in the real world, as we said, the reality of relying on the statutory defence is so difficult that perhaps it doesn't matter all that much that that defence is not available under the Protection from Harassment Act.
No. Probably something that is more of a practical reality, and if you have a client come in to say, I've been bullied, I've been harassed, is the timing under the Equality Act.
Absolutely,
because
very important.
We're all very well aware the limitation period is much shorter under the Equality Act and for the tribunal's jurisdiction, which is 3 months less a day.
Plus, now we have the extension for early conciliation.
Yes.
Let's say the maximum is currently about 5 months. If you put your early conciliation in right at the end of the 3 months, it's possible with the Employment Rights Bill that that could be extended, but we're talking maybe 6 months.
Yes.
But we're still talking about months, not years.
Yes.
Whereas civil claim,
6 years.
it's a 6-year limitation. It's a statutory tort. The time limit for tort claims is 6 years.
Yes.
And there is a specific carve-out actually in the Protection from Harassment Act that says that just that the 3-year exception for personal injury claims, so personal injury claims have a shorter time limit. For us employment lawyers, 3 years is still a long time. But for civil lawyers who are used to 6-year limitations, 3 years is not a long time. But the reduced 3-year limitation for PI claims does not apply to harassment claims. So it is definitely a 6-year limitation. That could be quite important because you may have a client coming to you about harassing or bullying behaviour and it may be way out of time.
Absolutely. And not to get split off onto a completely another topic, which we do a full webinar on extension of time, just next to, as a starting point, your 3 months plus your ACAS conciliation is the time you want to be focusing on.
Yeah, I mean, I suppose, not that I'm saying we should go into the weeds of this, but the fact is that the reason there are so many cases and so much case law and we spend so much time on extensions of time is because the time limit's so short. So therefore, and
it's not uncommon to have to deal with it.
It's not uncommon to have to deal with it. The reality in my civil practice is the time when you have to rely on Section 33 of the Limitation Act extension of time for limitation is very rare. In fact, most often crops up in PI claims where there is the 3-year limitation. 6 years is long enough that basically parties, if they're going to bring their claim, they're going to do it within the 6 years and there isn't going to be a time issue. Really, in practical terms. If it's beyond 6 years, you're probably sitting down with your client saying, do you really want to pursue this person for something that they did more than 6 years ago?
Yeah, that's a real issue. And may come back to bite you, as we were saying, in costs.
Absolutely. And of course, if you're saying I want an injunction, of course, an injunction won't be granted if the last thing that happened was more than 6 years ago. I promise you that.
It's not going to appear urgent. It's not going to appear required.
It has to be necessary to grant the injunction. And why would it be if the person hasn't been anywhere near you or spoken to you for more than 6 years?
Absolutely.
And your damages will be low or negligible because you've not done anything about it for more than 6 years, suggests that you weren't that upset by it. So in reality, in practical terms, in a protection from harassment claim, your time limits are just not going to be relevant. You're going to be in time. If you're upset enough to want to sue a person for harassing you, it's going to be within 6 years anyway.
So
should we go from the other
way
direction?
around?
Yes. And let's talk about the things you have to have for a Section 1 protection from harassment claim that you wouldn't need in a Section 26 tribunal claim. So the first most obvious one is that course of conduct bit, isn't it?
Yes.
So starting on my side with the Protection from Harassment Act, you have to have the 2 instances. One instance is never enough in a protection from harassment claim.
But a one-off incident, or I use the word incident, perhaps poorly there, because a one-off conduct can be enough to bring a harassment claim under Section 26 of the Equality Act. But there is a word of caution there. because it was the matter of General Municipal and Henderson.
Easy for you to say.
Yes, in 2015. And what that matter involved was the difference between perhaps an incident or an environment.
Right.
So the case, Henderson was employed as a regional organiser by the union. He was shouted at over the phone by the union general secretary. Now, to bring the facts shorter, it was found that that was harassment relating to his protected characteristics of left-wing democratic socialist beliefs.
So that's religious philosophical belief.
Yes.
Protected characteristic, okay.
However, the EAT found that the incident was insufficiently serious enough to give rise to an environment. It was an incident in which he was yelled at.
A single conversation in which he was yelled at.
Exactly. And the Court of Appeal upheld that view. So a one-off can be harassment for the Section 26, but as always, has to be considered on the facts of each case. It might not create an environment, particularly when, of course, when we're looking at the effect.
Right. And we remember going back to our definition of harassment under Section 26. It's either violating dignity or creating an intimidating, offensive environment. So that is part of the definition. Unless you're violating dignity, it's got to be that it creates an environment. And
I think the seriousness, that's reflected in that, because if it's going to be found to have violated dignity, I think that just sounds more serious in itself.
Well, I don't know about you, Max, but I can't think of a case that I've had in which the allegation is actually that the person's dignity has been violated. It's very rare. It happens, but it's a very rare pleading. The pleading is usually about creating an intimidating, offensive environment for the claimant. So that's important. Okay, so in principle, it's possible for a harassment claim under the Equality Act to be one event, but it still has to create an offensive environment.
Exactly.
With a protection from harassment claim, that is simply not possible. However serious the one event, it could be the most serious act of harassment ever. If it's not two events, it is not captured by the definition in Section 1, Protection from Harassment Act. So that is important. Obviously, as we've already said, the Protection from Harassment Act creates criminal and civil obligations.
Yes.
So that's a difference. Obviously, the Equality Act creates, civil obligations, but ones which can only be enforced in the Employment Tribunal. Under the Protection from Harassment Act, there's no need for a connection with any protected characteristic. Indeed, it's a complete irrelevance, really, what the reason or the context for the harassing behaviour is, actually, isn't it? As long as it did cause distress or alarm, and the person ought to have known that it was going to do that. That's all that's needed. And we've got the defence that the course of conduct can be excused, can be defended if it is reasonable for the person to conduct that behaviour. What's the equivalent of that in Section 26? I suppose it's our definition of effect, isn't it? If the purpose is to harass, that's it. But if the effect is harassment, but it's not reasonable for the person to have that perception,
that's where that element comes in. Yeah.
Ish. So it's a sort of similar test of reasonableness. In the Section 26 claim, it's the person's perception of the conduct being harassing that has to be reasonable. In a Section 1 claim, there's a defence of the defendant behaving in a way that was reasonable.
So subjective and objective versus the objective test on Section 1, I suppose. Yeah,
I think so. I think that the focus in Section 26 is on the subjective feelings of the individual who feels harassed, but subject to a sort of safety valve of reasonableness of that feeling. Whereas in the Section 1 claim, it's a much more sort of ordinary civil defence of, is the behaviour actually reasonable by the person who is alleged to have harassed the other person? And the example that tends to be given is a policeman carrying out his normal duties does things that would in any other context be considered quite probably to be harassment, but as it's a policeman undertaking his duties, in that context, it's reasonable. It's not harassing. We've talked about the fact that there isn't a defence of reasonable steps. It's the statutory defence because it's a pure vicarious liability situation for Protection from Harassment Act. And we've talked about the fact, very importantly, that you have an injunction available to you if you are claiming for protection from harassment.
Yes.
And we've talked about the 6-year limitation. So I think we've covered the big differences there.
I think so.
Should we talk about some examples of how this might play out in practice?
Yes. Well, I was thinking of, like, say, if a new client comes in, and you often see it described, and it's often included in pleadings. Somebody comes in and they say, well, I have been bullied. So it's a very common description. Could it fall under one or the other or both of the acts? So under the Equality Act, well, is bullying, I've been bullied, is that going to be unwanted conduct? Well, it sounds very obvious that it's very likely to be.
Yeah, so you're going to take instructions from that client about what's actually happened to them
Yes.
to make them say that they've been bullied. And if they're calling it bullying, like you say, most likely it's going to be unwanted conduct. So you can tick that first bit.
Sounds like
Section
it, doesn't
26.
And then we come to the second building block. So does it have the purpose or effect? Now, there you're having to, if it has the purpose, you're having to look into the eyes of the perpetrator, almost. Or then does it have the effect of this wording that is often interchangeable, create the intimidating, hostile, degrading, humiliating, or offensive environment? So
and that's a question for your client, because if you've got a client who's come in and says they've been bullied, you're asking them about their perception of how they feel based on that unwanted conduct.
Exactly.
Okay.
And that probably comes to a point of, yes, on the effect, and then of course it's got to link to the protected characteristic.
And that's the big thing, isn't it? That's the bit that you sometimes, in fact, I think you quite often get litigants in person who don't have legal advice for their claims, who issue claims where they refer to bullying in general terms. You get a judge at a first case management hearing saying something along the lines of, Mr. Bloggs, not everything that happens at work is a breach of the Equality Act. There has to be a connection with a protected characteristic. We've all had those hearings
absolutely,
where a claimant who hasn't had legal advice has raised something that just doesn't have the connection with any protected characteristic.
No, exactly. And we'll think about sort of some fact patterns that may not be quite as obvious a bit, but like you say, if it's just the person doesn't like me, it's, unless you can say anything more or any particular reason, then yes, that's not going to be harassment. And it's often the case, for example, you often see direct discrimination and harassment pleaded in the alternative. Absolutely. In the employment tribunal, because you're talking about it relating to a protected characteristic.
Yeah, so that makes sense to do that. If in fact you've got a new instruction and the client says they've been bullied and there isn't, and it's at work, but there isn't any connection with a protected characteristic and none that you can identify at all. And perhaps let's think about this realistically. It's not so unusual for there to be a possibility of pleading a protected characteristic connection, but it's not necessarily immediately obvious what that would be. What perhaps is a more useful example of a situation where you might actually genuinely put away the possibility of a Section 26 claim is if your client who comes to see you says, I've been bullied and I know exactly why it is. It's because my wife used to work in that business and she didn't get on well with this person and now I'm being targeted because they don't like my, just made that up, but something like that, where the individual, the client has a really particular belief that is concrete and based on real
they know something's happened.
They know exactly why they've been treated that way, and they're confident about that. And there's even evidence, say, to prove that that's the reason they've been treated that way. But it's actually demonstrably nothing to do with any protected characteristic.
No, like you say, on the other side of that coin, overt discrimination or overtly doing something because of a protected characteristic is quite rare. So that's where you need to look into it a bit more.
Absolutely. And I mean, it is worth saying that just because somebody doesn't immediately say to you when they come to see you as a new client, oh, I've been bullied because of my race, that doesn't mean it isn't because of their race. It's not straightforward. And it's going to be an extremely rare case, if we ever see one nowadays, when somebody refers explicitly to a protected characteristic. Perhaps age is one example where you do still see employers foolishly making statements which directly link behaviour to a person's age. But I think that's probably the only protected characteristic where that still can happen. Most of the time you're looking for inferences.
Yes.
So the fact there isn't an obvious link doesn't necessarily mean you can't run your Section 26 claim. But if that client is really clear about why something has happened, and it's definitely nothing to do with a protected characteristic, do you then talk them through the possibilities of a civil claim? I don't know, I mean, I suppose, Max, thinking about this, you'd only really be doing that if it was particularly serious. I'm not saying that harassment isn't serious, but the definition of harassment creating an offensive environment, for example, could, according to the perception of the individual, that could be very serious behaviour, or it could be along the scale of relatively minor to relatively serious behaviour. It might be less serious harassing behaviour. I think if you're going to advise a client to take the costs risk of pursuing an individual or a company through the county or court or high court for harassment under the Protection from Harassment Act and risk the costs and risk and spend all the money on that claim, the behaviour probably has to be particularly serious, and you have to be worried about stopping it. I think that's perhaps that's the difference, where you've got a client who says this person is harassing me, and I've got to get them to stop somehow. I need the court to make an order to make them stop doing this to me.
It perhaps underlines the distressing nature of it. I was trying to think, if you've got conduct that is alarming or distressing, is it likely to not then be sort of a hostile environment or
I think
a humiliating environment?
A significant crossover, isn't there?
Yes.
A very significant crossover. And it becomes not so much about whether it's distressing or alarming, more about, is it distressing and alarming enough to be worth pursuing? But I mean, I think that's right. I mean, perhaps we should also just touch on the particular extra element in Section 26, which doesn't exist in the Section 1 of the Protection from Harassment Act at all, which is the prohibition of sexual harassment. So there is the particular section, is it subsection 2, I think, of Section 26, that specifically prohibits harassment of a sexual nature. Now, the fact that doesn't exist in those words in Section 1, does that mean that you can sexually harass a neighbour or a person walking down the street?
No.
And not worry about it?
I was trying to think, why would they specifically draw it out in Section 26? The wording is unwanted conduct of a sexual nature. Yeah. And then it has the purpose of effect already referred to. I think it's got to be already wrapped up in the protection from harassment section.
I'll tell you why I think it is. It is because conduct of a sexual nature isn't necessarily particularly related to a protected characteristic. So let's say I'm a lecherous manager and I am lecherous with everybody, men and women. It's going to be very difficult for you to make a claim of harassment against me, because I'll say, well, I'm the same with men and women. It's nothing to do with sex.
So it's not.
So there's got to be a carve out or a specific section in the harassment part of the Equality Act that makes it clear that harassment that is of unwanted conduct that is of a sexual nature, irrespective of whether it's connected to any particular protected characteristic, is also prohibited. Yeah. So I think that's why it's done that way. But that then allows us perhaps to just see why Parliament didn't feel a need to include that in Section 1 of the Protection from Harassment Act, because you remember what the obligation is there. It's not to cause alarm or distress.
Yes.
Well, when is sexual harassment not going to cause either alarm or distress? Never. It's covered, isn't it? Because it's a much wider definition.
Yeah. No. On the point of the causing alarm and distress, to then flick back to the Equality Act point, and particularly thinking about the effect, there's a point of guidance how the effect test should be applied. It was a Richmond Pharmacology matter 2009.
Oh, that's Dhaliwal, isn't it?
Yes.
Yeah. Okay. So tell me about that.
It notes that the claimant must actually have felt or perceived the dignity being violated or the adverse environment. So they need to actually have felt it themselves. However, there is a point, I think, very importantly, that the conduct in question, as we've already touched on my example, it doesn't actually have to have been targeted at the complainant. Now, there are various cases which could show that it may be harder to prove or make out your claim of harassment in Section 26 if it's not targeted at you. But, for example, I can think it very common, perhaps if somebody sees harassment of another, that could then be a claim.
Or if a racist word is used within the hearing of another person, an employment tribunal judge is going to need no persuading that an individual who overhears a racially abusive word is going to feel the unwanted effect.
Yes, absolutely.
Okay, so that comparison is important. In the Protection from Harassment Act, there has to be actual alarm or distress caused. In the Equality Act, it can be the effect, but you still have to prove it actually had that effect on you.
Exactly.
It can't be that, that behaviour, that would offend anybody. Well, okay, but has it actually offended you? Because unless it has actually offended you, then Dhaliwal says Don't go any further.
And I had a case that became quite a pivotal point last year, despite what was put in all the claim form and the evidence that it was a Christmas time, as we are approaching December, gag gift.
Right.
It wasn't a gift to them, it was to their boss, and it had a sexual innuendo on it.
Right.
And they set out very clearly how this it had a really offensive effect on them. It created the environment. They were very clear.
Yeah.
However, then under cross-examination and evidence, they said, "Oh no, I get it. I like a good joke. Yeah, I thought it was funny."
And that's the end of that.
That was the end of that.
There's no effect.
Tribunal found it didn't have the effect that he had alleged, and therefore you don't then need to go through the other steps of the subsection 4 we talked about earlier.
Okay, now, Max, we've got a couple of scenarios, but I've also had a couple of questions come in from Sophie, from people watching the webinar. So can I suggest maybe you and I just cover one of the two examples?
Yeah.
Whichever one you fancy, we can pick. And then let's look at the questions after that to give us a bit of time to answer questions as well.
We'll just go over the one that was at the top. And this is purposely thought of to not necessarily be the clearest example, and we can sort of build on it as we go. So our complainant, Mandy, works in retail in a shift pattern. For a number of weeks now, her line manager, Greg, has given her what everybody seems to see as the worst shift timings. It means she always works the late shift. Yeah. This also includes doing a lot of the worst jobs and duties because you have to clean up after the long day, things you don't have to do on the earlier shifts. All her other colleagues all work in what appears to be a rota. They do the late shift sometimes, but only sort of when it seems to be their turn. Mandy's asked Greg about this at least twice and asked to change her shifts so that she rotates around. Greg's response is effectively, well, it's tough. She will work the shifts that he says that he gives her.
So he's repeatedly targeting her for worse treatment. And at the moment, based on the facts you've set out, we don't know why.
No.
But that's what's happening.
So putting aside the why just for a moment, could that potentially come under either the Protection from Harassment Act or the Equality Act is the first question. Okay,
so let's think that through. Let's start with the Equality Act then. I mean, you've said put aside the cause, but there has to be that connection with a protected characteristic before that can even get off the ground. But subject to that connection with a protected characteristic, I don't see why not. You've got something that could be creating an environment that is intimidating, offensive, etc. for Mandy. That's quite possible.
Clearly unwanted.
Absolutely clearly unwanted. And it's not difficult to believe that it would have that harassing effect on her. And it wouldn't be unreasonable if everybody else was getting normal treatment and she's getting negative treatment from this manager. I don't think a judge would have any difficulty in accepting that it was reasonable for her to be affected by it negatively.
Yeah.
So I think that could work, subject to the connection with protected characteristic.
Absolutely.
What about section 1? Well, if he's twice told her, no, you've just got to do it tough, then potentially that's 2 acts. That's a course of conduct.
Yeah.
That could amount to harassment. I think the difficulty might be causing her alarm or distress.
Yes.
That's, I think, where perhaps we touch on the difference between the definitions.
Yep. And the seriousness.
And I can see a county court judge, or indeed a high court judge, but I don't think you take this to the high court, a county court judge saying, why am I being asked about this? This is just the trivial, and this is, I think this is how a county court judge would view this. These are the trivial day-to-day events of a person's job. Why has this been turned into a protection from harassment claim in the county court?
So does it change if when Mandy has objected to this shift pattern, Greg has then shouted at her in response?
I think it depends on how much he's shouted at, doesn't it? Well, I mean, to some extent, being treated poorly at work is not so unusual, sadly. If it's sufficiently nasty behaviour on more than one occasion, importantly, to make her feel distressed, then in principle that could amount to a good Section 1 claim. Whether she'd want to take the risk of issuing a claim like that is another
we
matter.
Sort of touched on, are there some different thresholds here? If we're thinking generally the threshold under the Equality Act test might be lower. We went to the Henderson example. Now I know that was a bit more of it was a one-off, and so that was
the one-off argument over the phone
environment. But part of the reasoning there was that it wasn't serious enough to cause the environment by just being yelled at over the phone
on a single occasion. I mean, I think it's worth saying that in practical terms, employment tribunal judges see employment disputes all day, every day, and people treating each other badly at work, and they're used to fitting those into the various templates in sections 13, 15, 19, 20, 26, 27 of the Equality Act. That's normal, and a judge in an employment tribunal would have no hesitation in doing that if it fitted the criteria. In the county court, judges are just not used to dealing with employment disputes.
No.
So you are going to have probably a judge who is quite sceptical about whether this perhaps really unpleasant dispute at work is actually sufficient to give rise to alarm or distress that a reasonable person would think would cause alarm or distress.
I think
that's the practical problem with it, I think.
Yeah, I think you're right. And I think there is that practical element, like you say, of civil judges won't see protection from harassment acts very often. They will not see civil remedies sought.
That's extremely important, isn't it? It's not just that employment tribunal judges see employment claims all the time. It's also the converse, that county court judges very rarely see protection from harassment claims. The only ones I've ever dealt with in my practice in 20 years are stalkers and neighbours. Those are the two types of claims where you do get protection from harassment claims, where two neighbours are not getting on, and often each one makes a claim against the other of harassment under the Protection from Harassment Act, or former girlfriend, boyfriend, where there's a stalking element and a claim based on that. Those are the cases where it tends to come up. I don't think it's impossible to win a claim relating to an employment situation under Section 1 of the Protection from Harassment Act. But bear in mind the facts that we've just been discussing earlier on in this webinar about Titan Wealth Management. That was a case where the extreme nature of the behaviour, so you remember it was doctored indecent images of the individuals. It was sending out to everybody they knew allegations that they had got their job through sexual favours. I mean, the extent, the extremity of the behaviour was what led to that claim succeeding. It stands out as being extreme. Most, even very nasty, employment disputes, I think, would be very difficult to persuade a county court judge to be interested in, frankly, even if, technically speaking, that's a valid claim. So what you're looking at, I think, as an advisor is this a really unusually bad behaviour that we can't fit into Section 26? Then we should be considering a Section 1 injunction at that point.
Yeah.
Okay, shall we have a look at some questions?
Yeah.
Okay, let's have a look. Now, Max, I'm reading these without knowing what they say. So prepare to find out whether we know the answer or not. Here's a question. In terms of the reasonable steps defence, would I be right in thinking that in order to have one succeed, the employer would have had to take some action in the specific circumstances that led to the claim? For example, moving the harasser to a different department or suspending them. Would that potentially be considered enough? Do you have a view about that? I think I've probably got a view, but I'm interested to know what you think, Max.
I think that my first initial reaction is it too little too late, frankly. The harassment's already happened.
That's the problem. The harassment by that point has already happened. I totally agree with you. And the reality is, to the person who asked that question, that at the point when the first event happens that is alleged to be harassment, all an employer can do is point to their systems. You know, we have systems in place that tell people how they're supposed to behave. And what you could perhaps say is a slight tweak on what the questioner has asked is, you could point to other cases in which something has happened and that person has been immediately and strictly disciplined. And it's been made very clear to other staff that is completely unacceptable and it's against those policies. But in a sense, it's, I think, a given that has to have happened before, as you say, before the event, not after it, for it to amount to a good defence. That's why it's so difficult to win those defences.
It is. And I recently saw it almost framed the other way around, where it was an unfair dismissal case. But within the facts of this case, part of the issue was they had been dismissed for conduct towards someone they were managing. And they said, after the conduct, this long string of conduct, towards the end of this chronology, there was then we all had to attend this seminar, which was about managing people in certain circumstances, and why wasn't that rolled out earlier?
Yeah.
But I think the converse, obviously, in that case, the question then became: did you really need a seminar to tell you not to do X, Y, Z? And
yeah, you say that, but the very rare case I've had where I've run the argument. Essentially, that's what you end up saying to a judge. You say, do you really need, as an employer, to tell people not to harass staff? Well, then the judge says, yeah, you do.
Yeah.
You've got to be really clear about it and repeat it regularly and make a show of disciplining people who stray from the right way of behaving very, very clearly. And even that often isn't quite enough. Genuinely, I don't want to be cynical. I'm not cynical about the law. The law is generally speaking works very well when we can get a case listed within a year or two rather than 5. But if we can get a case to a trial, mainly the Equality Act works very well. I think it functions very well. The problem with the statutory defence is it doesn't function well. It is extremely difficult to meet, and in practice, judges just don't like it.
No, when you say cynical, I guess what I'm just trying to stress is we're pointing out the limit of the statutory defence. I'm not saying that there is then a limit to taking these steps in any way. Employers should be taking these steps.
Absolutely. And I think it's probably worth saying to the person who asked this question that if somebody has begun to harass somebody else and the steps are not taken to remove them, then that is even worse. Absolutely. So that's important. Okay, I think we've got time. It's 6. We've got time for maybe just one more short question. This is a good one. Have you seen cases where an employee is being harassed in the course of employment by a third party, such as a customer? So that's a little bit the example that you gave earlier, although we were talking about whether it was sufficient to have the effect. But that was a customer feedback form. What about cases where an employee is being harassed in the course of employment by a third party, such as a customer, and where the employer has agreed to support or fund the employee bringing a claim under the Protection from Harassment Act 1997? I'm aware employees expect an employer to do something to protect them in such circumstances. I'm not aware of any employer who's got any kind of policy or habit or custom of supporting that kind of claim. I think the reality is that if a customer is actually racially harassing or sexually harassing a member of staff, the business bars that customer from the premises and says, we're not having that person back here again. I think in practical terms, that's what happens. And I have never seen an employer willing to fund a Protection from Harassment Act claim. The difference, which is proved by the extreme facts, is Titan Wealth Management, which ran that entire High Court claim against the individual, Ms. Okunola, in support of the 2 managers who were being targeted, and also because its own reputation. I mean, let's not be, too sort of rose-tinted spectacles about this. They also had their company reputation being affected, and they were running the case in order to deal with that problem.
I think, as reflected in Titan, I think perhaps I could see it being more relevant because of the digital age. So you can bar someone from the premises, doesn't stop them jumping online, tweeting, writing reviews, being abusive, online bullying, effectively.
Absolutely. I mean, it's a very interesting question. I mean, I suppose the more I think about it, the more I think perhaps there does need to be at least consideration of those other sorts of steps that might be taken by an employer, either to assist an employee or to fund an employee, or if possible, perhaps to run the claim themselves, if it can be argued that their own reputation is also being affected.
Yeah, of course. I mean, I do know, for example, I think it applies more in larger scale companies, but with the increased availability of AI, perhaps more readily available, algorithms are used to weed out and delete out, offensive comments and, racism and things like that. So it prevents it getting to employees. So I suppose that is a step already being taken.
I suppose so. Although, sometimes that happens as a matter of course without anyone really thinking about it particularly. And I guess this question is, well, what should an employer actively do in order to protect employees who are being harassed by customers? I think probably, should we chalk that down to a very good question? And we don't really know the answer to it. And certainly I would say my experience is that nobody uses the Protection from Harassment claim in such situation, Protection from Harassment Act in such situations, and maybe they should. Maybe it should start to be considered. Okay, well, thank you everybody for joining us. Thank you, Max, for having this conversation with me. It's been great fun. And just a reminder to everybody that you can email your questions through now or when you watch this later. You can email your questions through to events@42br.com. The recording will be available on the website and the YouTube channel shortly, and we would be very grateful to you for any feedback that you can give us. That is it, folks, for 2025 Employment Law webinar series. Please do keep an eye out for our 2026 series of employment webinars, which will be advertised shortly. Thank you very much.
Thank you.
Goodbye.
Goodbye.